Now more than ever, people are finding videos of themselves uploaded to social media without their consent. Sometimes it's embarrassing, sometimes it's invasive, and in some cases, it amounts to a violation of your privacy. If this has happened to you, it's important to understand that you do have rights, and there are legal steps you can take to regain control of your digital footprint. A lot of people assume that the moment they step into a public place, they lose all rights to privacy, but that simply isn't true. Yes, in England and Wales, there's generally no law from stopping people from filming or photographing others in public, but taking a video and publishing it online are two very different things. Just because someone can film you in public, it does not give them the automatic right to be able to publish that footage on TikTok or Instagram or YouTube or any other platform, especially where that video will cause harm, distress, alarm, humiliation, or will interfere with your private life. The law recognizes that people can still have a reasonable expectation of privacy in public settings. That expectation depends on the context. If the video is intrusive, misleading, exploitative, or is shared to shame someone, the legal position can change significantly. And importantly, your image, your face, your likeness, your identity still belongs to you. Someone does not gain ownership over those things because they pointed a camera in your direction. In many cases, if your image or video is uploaded without your consent, you have the right to request its removal. If the individual who published the content refuses, or it's impractical to contact them, you can often report the content to the platform itself, requesting that the content is either de-indexed or removed. There can also be data protection implications. Under UK GDPR and data protection laws, videos and photographs of identifiable individuals are considered personal data. This means that the collection and the sharing of that content must be fair, lawful, and transparent. In some circumstances, uploading a video of someone without their consent amounts to unlawful processing of personal data, particularly where there is no legitimate reason for posting the video itself or if the individual's privacy outweighs any public interest. The law also provides individuals with important rights, including the right to object harmful processing, and in some circumstances, the right to have the content removed altogether. And then there's harassment. Under the Protection from Harassment Act 1997, harassment is generally defined as a course of conduct directed at another person which causes alarm, distress, humiliation, or fear of violence. For behavior to amount to a course of conduct, it must usually occur on more than one occasion. At first glance, you might think a single uploaded video doesn't qualify. But social media has changed the way that we look at these situations. A single post can be viewed, shared, commented on, or reposted hundreds or thousands or millions of times. The harm caused does not necessarily end when the video is uploaded. Every share, every comment, every repost can prolong the distress caused to the victim. So whilst the law traditionally required repeated acts, the permanence and amplification of online content means that just one upload can have continuing consequences. Ultimately, if you feel that your privacy has been violated, you should not assume that you are powerless. Legal remedies are available, and in many cases, action can be taken to remove the harmful content and hold those responsible accountable. If you or someone you know has been affected by a video published online without your consent, it's important to know that legal advice is available, and taking early action can make a significant difference, especially before the content spreads further online. At Cohen Davis, we're here to help.